Part 1 Care and Protection of Children. 4. 1. For the purpose of protecting and enforcing the rights of children, there is hereby established a Commission of Parliament which shall be known as the Children's Advocate. 2. The provisions of the first schedule shall have effect with respect to the constitution and functions of the Children's Advocate. 3. Where in any proceedings a child is brought before the court and it appears that the child is in need of legal representation in those proceedings, the court shall a. Refer the case to the Children's Advocate or, if the court thinks fit, grant a legal aid certificate in such circumstances as may be prescribed. b. If the court thinks fit, adjourn the proceedings until such time as the court considers sufficient to allow for, as the case may be, I. The Children's Advocate to consider the case, or 2. The necessary arrangements to be made for the child to obtain legal representation pursuant to the legal aid certificate, and c. Cause to be delivered to the Children's Advocate a notice of its determination under this section. 5.1. For the purposes of this Act there shall be a Children's Register and a Children's Registry. 2. The Children's Register shall consist of such information as is supplied by persons who are required to make a report under Section 6. 3. The Minister may make regulations prescribing the procedure for the entry of information into the Register, the form and contents of the Register, the appointment and duties of officers and staff of the Registry, the location of registration centres, and any other matter necessary to give effect to the provisions of this section. 6i. In this section, prescribed person means a. A physician, nurse, dentist or other health or mental health professional. b. An administrator of a hospital facility. c. A school principal, teacher or other teaching professional. d. A social worker or other social service professional. e. An owner, operator or employee of a child day care center or other child care institution. f. A guidance counselor, or g. Any other person who by virtue of his employment or occupation has a responsibility to discharge a duty of care towards a child. Relevant regulatory entity means the entity authorized by law to regulate the professional activities of a prescribed person. 2. Any person who has information which causes that person to suspect that a child a. has been, is being or is likely to be, abandoned, neglected or, physically or sexually ill-treated, or b. is otherwise in need of care and protection, shall make a report to the registry. 3. A prescribed person who, in the discharge of that person's duties, acquires information that ought reasonably to cause that person to suspect that a child a. has been, is being or is likely to be, abandoned, neglected or, physically or sexually ill-treated, or b. is otherwise in need of care and protection, shall make a report to the registry in accordance with the provisions of this section. 4. A person who contravenes subsection 2, or 3, commits an offence and shall be liable upon summary conviction before a resident magistrate to a fine not exceeding $500,000 or to imprisonment to a term not exceeding 6 months or to both such fine and imprisonment. 5. Where the Minister has reasonable grounds to suspect that a prescribed person has committed an offence under subsection 4, the Minister may, without prejudice to any proceedings under that subsection, require the relevant regulatory entity to cause an investigation to be made into the matter. 6. No action shall lie in respect of any person who makes a report to the registry in good faith pursuant to this section. 7. A report to the Children's Registry shall a. be made as soon as is reasonably possible, b. be in such form as may be prescribed, and c. contain all the material facts giving rise to the suspicion that the child has been, is being or is likely to be, abandoned, neglected, physically or sexually ill-treated, or is otherwise in need of care and protection. 8. A person who knowingly makes a false statement in a report to the Children's Registry commits an offence. 9. Subsection 2 or 3 applies even if the information on which the belief is based A. is privileged as a result of a relationship of attorney-at-law and client, or B. is confidential, unless there is no substantial risk that the welfare of the child will be further endangered. 7. 1. On receiving a report about a child under Section 6, the registrar shall assess the information in the report and, after such assessment, may A. refer the report to the children's advocate and the government agency responsible for children for further investigation or so that the child may be brought before a court under Section 13, as the case may require. B. Inform the person having custody, care or control of the child of the report, unless, in the opinion of the registrar, such information would cause physical or emotional harm to any person, endanger the safety of the child or impede an investigation under paragraph A. 2. Every person shall regard as secret and confidential every report made under Section 6 and shall not, other than in any proceedings for an offence or as is permitted for the purposes of this Act, disclose A. the existence of the report or any information contained therein, or B. any other information from which the identity of I. any child concerned in the report, or 2. any person alleged in the report to have committed an offence in respect of any such child, may be reasonably inferred. 3. A person who contravenes subsection 2 shall be liable upon summary conviction before a resident magistrate to a fine not exceeding $500,000 or to imprisonment for a term not exceeding 6 months, or to both such fine and imprisonment. 4. The registrar commits an offence if the registrar A. fails to assess any report referred to in subsection 1, or B. fails, without good cause, to refer the report in accordance with subsection LA. 5. A person to whom a report is referred for investigation under subsection LA, other than the children's advocate, commits an offence if that person fails to carry out the investigation. 8. 1. For the purposes of this Act, a child shall be considered to be in need of care and protection if that child, A. having no parent or guardian, or having a parent or guardian unfit to exercise care and guardianship, or not exercising proper care and guardianship, is falling into bad associations, exposed to moral danger, or beyond control. B. is being cared for in circumstances in which the child's physical or mental health or emotional state is being seriously impaired or there is a substantial risk that it will be seriously impaired. C. is a child in respect of whom any offence mentioned in the second schedule has been committed or attempted to be committed. D. is a member of the same household as a child in respect of whom such an offence has been committed, or E. is a member of the same household as a person who has been convicted of such an offence in respect of a child. 2. For the purposes of subsection I, the fact that a child is found A. destitute, B. wandering without any settled place of abode and without visible means of subsistence, C. begging or receiving alms or loitering for that purpose, shall, without prejudice to the generality of the provisions of subsection 1, A. be evidence that the child is exposed to moral danger. 9. 1. A person commits an offence if that person, being an adult and having the custody, charge or care of any child willfully, A. assaults, physically or mentally ill-treats, neglects, abandons or exposes such child, or B. causes or procures the child to be assaulted, physically or mentally ill-treated, neglected, abandoned or exposed, in a manner likely to cause that child unnecessary suffering or injury to health, including injury to or loss of sight, or hearing, or limb, or organ of the body, or any mental derangement. 2. A person who commits an offence under subsection 1 shall be liable, A. On conviction on indictment in a circuit court, to a fine or to imprisonment with hard labor for a term not exceeding 5 years, or to both such fine and imprisonment. B. On summary conviction before a resident magistrate, to a fine not exceeding $1 million or to imprisonment with hard labor for a term not exceeding 3 years, or to both such fine and imprisonment.
Cruelty to children, continued. 3. For the purposes of this section, the persons specified in paragraphs A to C shall, in the circumstances described in those paragraphs, be deemed to have neglected a child in a manner likely to cause injury to the child's health, that is to say, A parent or other person legally liable to maintain the child who, being able to do so, fails to provide for the child in accordance with any duty imposed by Section 27 or 28. B. An adult with whom an infant under 3 years of age was in a bed, where it is proved that I. The infant's death was caused by suffocation, not resulting from disease or the presence of any foreign body in the infant's throat or air passages, and 2. The adult was, at the time of going to bed, under the influence of drink or any drug. C. Any adult having the custody, charge or care of any child, who allows that child to I. Be in any room or yard containing A. Any body of water, whether naturally or artificially formed or stored in a container, or B. A stove, coal stove, or open flame, or 2. Have access to any poisonous or flammable substances not sufficiently protected to guard against the risk of that child being drowned, poisoned, burnt or scalded, as the case may be, without taking reasonable precaution against the risk, and by reason thereof that child is killed or suffers serious injury. Provided that neither this paragraph nor any proceedings taken thereunder shall affect the liability of any person to be indicted for manslaughter or for any offence against the Offences Against the Person Act. 4. Any adult other than an owner or operator in the circumstances referred to in Section 40, who gives, or causes to be given, or sells, or causes to be sold, to any child any intoxicating liquor, except upon the order of a duly qualified medical practitioner for the purpose of treating sickness, or in case of other urgent cause, shall be deemed to have ill-treated that child in a manner likely to cause injury to the child's health. 5. A person may be convicted of an offence under this section. A. Notwithstanding that actual suffering or injury to health, or the likelihood of actual suffering or injury to health, was obviated by the action of another person. B. Notwithstanding the death of the child in respect of whom the offence is committed. 6. Upon the trial of any adult for infanticide or for the manslaughter of a child of whom the adult had the custody, charge, or care, it shall be lawful for the jury, if they are satisfied that the adult is guilty of an offence under this section, to find that adult guilty of that offence. 7. If it is proved that a person convicted under this section was directly or indirectly interested in any sum of money accruing or payable in the event of the death of the child, and had knowledge that that sum of money was accruing or becoming payable, then A. In the case of a conviction on indictment before a circuit court, the court may impose a fine or sentence that person to imprisonment with hard labor for any term not exceeding 10 years, or impose both such fine and sentence. B. In the case of a summary conviction before a resident magistrate, the maximum amount of the fine which may be imposed under this section shall be $1,500,000, and the resident magistrate may, instead of any other penalty, sentence that person to imprisonment with hard labor for any term not exceeding 5 years, or impose both such fine and sentence. 8. For the purposes of subsection 7. A. A person shall be deemed to be directly or indirectly interested in a sum of money if he has any share in or any benefit from the payment of that money, notwithstanding that he is not the person to whom it is legally payable. B. A copy of a policy of insurance, certified to be a true copy by an officer or agent of the insurance company granting the policy, shall be Evidence that the child therein stated to be insured has in fact been so insured and that the person in whose favor the policy has been granted is the person to whom the money thereby insured is legally payable. 9. Any reference in this section, section 53 or 57 to a resident magistrate, insofar as it relates a. to a resident magistrate for the parish of Kingston or for the parish of St. Andrews shall be construed as a reference to a judge of the Family Court Corporate Area Region, and b. to a resident magistrate for a parish within the geographical jurisdiction of the Family Court established pursuant to Part 2 of the Judicature. Family Court Act shall be construed as a reference to a judge of that family court. 10-1. No person shall sell or participate in the trafficking of any child. 2. Any person who commits an offence under subsection 1 shall be liable on conviction on indictment before a circuit court, to a fine or to imprisonment with hard labour for a term not exceeding 10 years, or to both such fine and imprisonment. 11-1. If it appears to a justice of the peace on information on oath laid by any person who, in the opinion of the justice of the peace is acting in the interests of a child that there is reasonable cause to suspect a. that the child has been or is being assaulted, ill-treated or neglected in a manner likely to cause that child unnecessary suffering, or b. that any offence mentioned in the second schedule has been, is being or is likely to be committed in respect of the child. The justice of the peace may act in accordance with subsection 2 or 3. 2. The justice of the peace may issue a warrant a. authorizing any constable
I. to search for the child and, if it is found that the child has been, is being or is likely to be assaulted, ill-treated or neglected in any such manner, or that any such offence has been or is being committed in respect of the child, to remove the child to and detain the child in a place of safety, or 2. to remove the child with or without search to a place of safety and to detain the child there, and bring the child before a children's court or, if there is no children's court sitting in that parish, before a resident magistrate in chambers, within 48 hours after such removal, or b. causing any person accused of any offence mentioned in subsection 1, in respect of the child to be apprehended and brought before a court of summary jurisdiction in order that proceedings may be taken against him according to law. 3. Instead of authorizing the removal of a child under subsection 2, the justice of the peace may make an order prohibiting any person accused of any offence mentioned in subsection 1, in respect of the child from a. entering or remaining in the household residence where the child resides, or b. following or waylaying the child in any place, until such time as the child is brought before the court. 4. Copy of an order made under subsection 3 shall be served personally on the person accused of the offence, who may apply immediately to the justice of the peace for the order to be discharged. 5. In determining whether to discharge the order, the justice of the peace shall have regard to the matters referred to in subsection I. 6. Any constable authorized by warrant under this section to search for any child, or to remove any child with or without search, may enter, if need be by force, any house, building or other place specified in the warrant and may remove the child therefrom. 7. The constable executing any warrant issued under this section may be accompanied by the person laying the information, if that person so desires, and may also, if the justice of the peace by whom the warrant is issued so directs, be accompanied by a duly qualified medical practitioner. 8. It shall not be necessary in any information or warrant under this section to name the child. 12.1. A constable, a children's officer or a probation and aftercare officer may take to a place of safety any child in respect of whom any of the offences mentioned in the second schedule has been committed, or there is reason to believe has been committed, or who is, in accordance with the provisions of section 13, about to be brought before a children's court. 2. Any child taken to a place of safety under this section, or any child who seeks refuge in a place of safety, shall not be detained there for longer than 48 hours without having been brought before a children's court or, if there is no children's court sitting in that parish, a resident magistrate. In chambers. Power to bring child needing care or protection before the court. 13.1. Any constable or authorized person may bring before a children's court any child in need of care or protection. 2. For the purposes of this section, the expression authorized person means a. Any probation and aftercare officer or any children's officer. b. Any person appointed by the minister under Section 87, including any person appointed by the minister on the recommendation of a welfare organization. 14.1. A children's court before which any child is brought under this part, or before which is brought any child in respect of whom any of the offences mentioned in the second schedule has been committed, may, if satisfied that the best interests of the child so require, make an order. In accordance with subsection 2. 2. An order under subsection 1 may a. Require the child's parent or guardian to enter into a recognizance to exercise proper care and guardianship. b. Commit the child to the care of any fit person, whether a relative or not, who is willing to undertake the care of the child. c. Either in addition to, or without making any order under paragraph a, or b, place the child for a specified period not exceeding 3 years under the supervision of a probation and aftercare officer, or some other person to be selected for the purpose by the minister. d. Prohibit for a specified period, not exceeding 2 years, any person found guilty of such offence. I. From entering onto or residing at any premises at which the child resides, including premises the person owns or has a right to occupy, or 2. From contacting or interfering with, or attempting to contact or interfere with, the child, except that where such person is the child's parent, the order may set out such conditions for supervised contact between that parent and the child, as the court may think fit, having regard to the best interests of the child. e. If there are reasonable grounds to believe that a person is likely to interfere with a party who has custody of a child, prohibit that person from contacting or interfering with, or attempting to contact or interfere with, the party who has custody of the child. f. Where any person found guilty of such offence as a person having the custody, charge or care of the child, require I. That person, or 2. The child or any other child who resides with that person, to receive counseling for a specified period from a fit person, qualified by his knowledge of psychology or psychiatry, appointed by the court. 3. The government agency responsible for children or any party to proceedings under this section may apply to the court for a variation or discharge of an order, if circumstances have changed significantly since the order was made. 4. Notice of any application under subsection 3 shall be given to all other parties to the proceedings at least 7 days before the date set for hearing the application. 5. If a children's court before which any child is brought is not in a position to decide whether any or what order ought to be made under this section, it may make such interim order as it thinks fit for the child's detention or continued detention in a place of safety, or for his committal to the care of a fit person, whether a relative or not, who is willing to undertake the care of the child. 6. any interim order made under subsection 5 shall not remain in force for more than 30 days, but at any time within such period the court may, if it considers it expedient so to do, make a further interim order, so, however, that in no case shall any interim order remain in force for more than 60 days after the date of the first order made under subsection 5. 7. If the children's court by which an interim order is made is satisfied on any occasion that, by reason of illness, accident or other justifiable cause the child is unable to appear personally before the court, any further interim order which the court has power to make on that occasion may be made in the absence of the child. 8. In making an order under this section for the committal of a child to the care of a fit person or for placement of a child in a place of safety, the court shall consider the child's best interests and give priority to placing the child with a relative or, if that is not consistent with the child's best interests, committal or placement of the child as follows. A. In a location where the child can maintain contact with relatives and friends. B. In the same family unit as the child's brothers and sisters. C. In a location that will allow the child to continue in the same school. 15. 1. Any constable may take into custody, without warrant, any person who a. Commits, within his view, any of the offences mentioned in the second schedule. B. Has committed, or whom he has reason to believe to have committed, any such offence. If the constable has reasonable grounds for believing that such person will abscond, or if the constable does not know and cannot ascertain that person's name and address. 2. Where, under the powers conferred by this section, a constable arrests any person without warrant, the officer or sub-officer of the police in charge of the station to which that person is brought shall grant the person bail in accordance with the Bail Act, unless he believes, on reasonable grounds, that the release of that person on bail would tend to defeat the ends of justice, or to cause injury or danger to the child against whom the offence is alleged to have been committed. 16. 1. Where a person is charged with committing any of the offences mentioned in the second schedule in respect of 2 or more children, the same information or summons may charge the offence in respect of all or any of them, but the person charged shall not, if he is summarily convicted, be liable to a separate penalty in respect of each child except upon separate information. 2. The same information or summons may also charge any person as having the custody, charge or care, alternatively, or together, and may charge him with a. The offence of assault, ill-treatment, neglect, abandonment, or exposure, together or separately, and b. Committing all or any of those offences in a manner likely to cause unnecessary suffering or injury to health, alternatively or together. But when those offences are charged together, the person charged shall not, if he is summarily convicted, be liable to a separate penalty for each. 3. Where a person is charged with any offence mentioned in the second schedule, and the offence is a continuous offence, it shall not be necessary to specify in the information, summons or indictment the date of the acts constituting the offence. 17. Where in any proceedings with relation to any of the offences mentioned in the second schedule the court is satisfied that the attendance before it of any child in respect of whom the offence is alleged to have been committed is not essential to the just hearing of the case may be proceeded with and determined in the absence of the child. 18. 1. Where a justice of the peace is satisfied by the statement of a duly qualified medical practitioner that the attendance before a court of any child, in respect of whom any of the offences mentioned in the second schedule, is alleged to have been committed, would involve serious danger to the life or health of the child, the justice of the peace may take in writing the deposition of the child on oath, and shall Thereupon subscribe the statement and add thereto a declaration of his reason for taking it, and of the date on which, and the place where, it was taken, and of the names of the persons, if any, present at the taking thereof. 2. The Justice of the Peace taking any such statement shall transmit it with the Justice's declaration. A. If the statement relates to an offence for which any accused person is already committed for trial, to the proper officer of the court for trial at which the accused person has been committed. B. In any other case, to the clerk of the court before which proceedings are pending in respect of the offence. 19. Where, in any proceedings in respect of any of the offences mentioned in the second schedule, the court is satisfied by the evidence of a duly qualified medical practitioner that the attendance before the court of any child, in respect of whom the offence is alleged to have been committed, would involve serious danger to the child's life or health, any deposition of the child taken under Part I of the Justices of the Peace Jurisdiction Act, or under this part of this Act, shall be admissible in evidence either for or against the accused person without further proof thereof if it purports to be signed by the Justice of the Peace by or before whom it purports to be taken. Provided that the deposition shall not be admissible in evidence against the accused person unless it is proved that reasonable notice of the intention to take the deposition has been served upon him and that he or his attorney at law had, or would have had if he had chosen to be present, an opportunity of cross-examining the child making the deposition. Evidence of child of tender years. 21. Subject to subsection 2, where, in any proceedings against any person for any offence, any child of tender years called as a witness does not in the opinion of the court understand the nature of an oath, the child's evidence though not given upon oath, A. may be received, if, in the opinion of the court, the child is possessed of sufficient intelligence to justify the reception of the evidence, and understands the duty of speaking the truth. B. If otherwise taken and reduced into writing in accordance with the provisions of Section 34 of the Justices of the Peace Jurisdiction Act, or of this part, shall be deemed to be a deposition within the meaning of that section and this part, respectively. 2. Where evidence admitted by virtue of this section is given on behalf of the prosecution, the accused shall not be liable to be convicted of the offence unless that evidence is corroborated by other material evidence in support thereof implicating him. 3. In this section, child of tender years means a child under the age of 14 years. 21. 1. Where a child is brought before the court as being in need of care and protection, and there is reason to believe that the child has been abused, the court may, of its own volition or on the application of the child's parent or guardian, a constable or authorized officer, or the children's advocate, make an order requiring that the child be medically examined for the purposes of determining what steps ought to be taken in relation to the health and medical treatment of the child. 2. A medical practitioner acting pursuant to an order made under subsection 1, may carry out, or cause to be carried out, such medical examination of the child as the medical practitioner thinks fit and shall, as soon as practicable, transmit a report thereon to the court. 3. No proceedings shall be brought against a medical practitioner for anything done in good faith in accordance with the provisions of this section. 22. 1. Where a person is charged with or convicted of an offence in respect of a child, being a. An offence under the Offences Against the Person Act, namely Section 40, aggravated assaults on women or children, 47. Defilement of female imbecile, 48, carnal knowledge of girl under 12, 50, above 12 and under 16, or 53, indecent assault, etc., or b. Any offence involving conduct likely to result in the transmission of a communicable disease to a child, the court may make an order requiring such person to submit to medical examination and testing for the purpose of ascertaining whether such person is the carrier of a communicable disease, if the court is satisfied that such examination and testing is in the best interests of the child. 2. A person having knowledge or possession of information relating to any examination or test carried out under subsection 1, shall regard and deal with such information as secret and confidential, and any such person who communicates or attempts to communicate such information to any person, a. other than to a person to whom he is authorized to communicate it, or b. otherwise than for the purposes of this Act, commits an offense and shall be liable on summary conviction before a resident magistrate to a fine not exceeding $1 million, and in default of payment to imprisonment for a term not exceeding 12 months. 3. An order made under this section may give directions in respect of such ancillary matters as are necessary for the proper carrying out of the order and for such communication of the results of any examination or test as is necessary in the best interests of the child. 23. 1. Where a person having the custody, charge or care of a child has been a. convicted, in respect of that child, of any of the offences mentioned in the second schedule, b. committed for trial for any such offence, or c. bound over to keep the peace towards that child, by any court, that court may order that child to be brought before a children's court with a view to the said court making an order under section 14, and shall direct that the minister and the probation and aftercare officer be informed, as soon as practicable, of the order made. 2. Where any court has, under this section, made an order directing that a child be brought before a children's court, it shall be the duty of the following persons to bring the child before the children's court. A. The complainant, if he is a constable, in the proceedings against the person having the custody, charge or care of the child. B. If that complainant is not a constable, the senior constable present in court at the time that the order was made, or c. a children's officer. 24. 1. The parent or guardian of a child may bring the child before a juvenile court, and where such parent or guardian proves to the court that he is unable to control the child, the court may make an order in respect of the child if satisfied a. that it is expedient so to deal with the child, and b. that the parent or guardian understands the results which will follow from, and consents to the making of, the order. 2. An order under subsection 1 may a. be a correctional order, or b. provide for the child I. to be committed to the care of any fit person, whether a relative or not, who is willing to undertake the care of the child, or 2. to be placed for a specified period, not exceeding 3 years, under the supervision of a probation and aftercare officer, a. children's officer or of some other person to be selected for the purpose by the minister.